That was 1887. And next up, our last case of the day, we have 1819-87, Shamrock versus REMARK.
He's the boss. You got to ask him. She's asking about him.
Oh, I'm sorry, counsel. What's the question?
I apologize. I was asking if I could proceed.
Oh, yes, whenever. Oh, well, counsel, how much time would you like in rebuttal?
I'd like to reserve 5 minutes for rebuttal, Your Honor.
Just 1 second. Let me set the clock here, and whenever you're ready.
Thank you. May it please the Court, Dorothy Easley on behalf of SHAMROCK-SHAMROck, and we're here today on a very narrow legal issue, which is to ask the Court to reverse summary judgment entered on the spoliation element of duty to preserve. But the legal issue does have far-reaching implications and policy concerns, which we're happy to discuss as well. But for purposes of this argument, until the Court asks me questions, what I'd like to do is focus on what happened below and the cases that were relied upon going in one direction and the cases that we rely on going in the other direction. REMARK argued for, and the lower court accepted, a spoliation rule that you can only preserve evidence if there's a statute, a contract, or a discovery request. A subpoena ducis tecum is the term the court used at the summary judgment hearing, record site 96-97.
You rely on the Legal and Voters v. Stetzer case to suggest that that rule is inapplicable now in Florida.
That rule is inapplicable, and it's been inapplicable since 1996 in the St. Mary's versus Brinson decision. And to answer your question, I'd like to run through those cases. Because we have the St. Mary's versus Brinson decision.
You're arguing the notice or knowledge of litigation, essentially, right?
Exactly, okay. Exactly. And to cut to the chase, of course, the most recent decision is the Florida Supreme Court Detzner decision.
Which, I'm sorry, I didn't hear that.
The Florida Supreme Court Detzner decision, and the Detzner decision cites with approval the Hediger decision, also out of the 4th District Court of Appeal, the 2004 decision. But this court also rendered the en banc decision of Torres, and we quote Chief Judge Harris's concurring opinion in that, which explains the reason for the rule. And in Torres, the court used the description of contemplated litigation. And so this idea that...
To get to the sort of core of the issue, though, do you think there's a difference between spoliation by a party to the litigation versus a non-party?
Yes, Your Honor. Of course, there would be multiple differences. The first difference is...
legally, what are the legal differences there?
Well, that's a first-party spoliation claim as opposed to a third-party spoliation claim. This court knows that. And in the first-party spoliation claim, the duties are the same, first party versus third party. But in a first-party spoliation claim, the remedy's different, because what happens, as the court appreciates, is the court...
Well, are
the
we
lower
to
court
expect...
sanctions.
I mean, fair enough, but let's back up a little bit. Are we to expect a non-party to litigation to have the same knowledge of the issues and the need to preserve evidence as a party? Are they on the same footing there?
In a first-party spoliation, answering your question, that knowledge is much greater, and that's why the sanctions are much greater. That's why you can have your pleading stricken in a first-party spoliation case. In a third-party spoliation case...
in a third-party spoliation case, you don't have pleadings, right? You're not a party.
Exactly.
So that's
and that's what...
I'm not sure that is a good distinction, because you don't even have pleadings to strike.
Well, I think...
But in this case, instead of striking pleadings, the third party is getting sued for damages.
Exactly.
How is that any less severe than striking pleadings?
Well, it's less severe because these issues go through jury determination. Getting back to the Flagstar decision out of the
Isn't the issue, though, whether there's a duty? So even in the Dessner case, the dicta regarding you should be able to anticipate litigation suggests that there wasn't a legal duty in that case, but there was these evidentiary inferences that could be applied. So how do we extend that analysis to suggesting there's a legal duty on a third party who's just supposed to anticipate what they're supposed to do?
Well, Dessner, there was no litigation. St. Mary's versus Brinson, Hediger, Hagopian,
Right,
no
there
litigation.
was no litigation and also no legal duty found.
Oh, with respect, Your Honor, in Dessner, there was legal
That involved a
duty
party,
found.
though, right? I mean, in Dessner, it said, even in the absence of a legal duty, though, the spoliation of evidence results in an adverse inference against the party
That's
that
right.
discarded or destroyed the evidence.
Once they get sued, and to further answer your question, in the Hediger decision, well, actually Flagstar decision, that case actually went through jury trial on duty, on damages, all of the elements of spoliation, significant impairment, all of those issues went through jury trial. The reason the appellate court reversed was because the jury instruction went too far.
Was that a first party spoliation claim or third party?
It was third party. It started out as third party spoliation. The only reason we have reported decisions on third party spoliation is because they ultimately go to spoliation. In other words, it will be circular, as the appellee argues, that there's no such thing as a third party spoliation
Was
unless they're
REMARK served with the complaint?
No, Your Honor. She is named in the third amended complaint, paragraph 17.
Was she served with it?
No, Your Honor. She
was
is
served
named.
with notices for deposition, right?
She was served with notices of deposition
complaint
starting in
served on
May
her-
2011.
Was the complaint served on her with the notices of deposition?
No, Your Honor. She was not served
How
with
does
a
a third
complaint.
party, a non-party to the litigation, how are they to be expected to know all of the issues that are related to the, I mean, just generally speaking, not in this case, generally speaking, if we set a rule, or write an opinion on the issue and say, a third party, a non-party to the litigation has this duty in this case, how are they to know what to preserve if they don't have the complaint?
Because, Your Honor, when they are involved in the transaction, or they're involved in the accident, or they're involved in some form of related litigation, and in this case, there was administrative litigation, there was an ongoing dispute, and REMARK was specifically involved in that. She submitted a 4-page letter with 21 pages of attachments to it. She was involved in this dispute about the permitting approval of Shamrock's property. In that situation, and I understand where the court's going, it's like, how do we balance this fairness? But in that situation, the court says you, the spoliator, are not, you get the adverse inference. It's assumed you, I'm sorry, Your Honor.
Hypothetical. I witness an accident, and so I make a 911 call on my cell phone to the police to report what I have seen. And, I leave. And then litigation ensues over the accident, and there's a dispute as to whether I had called or seen the accident, and whether I had called 911. But I have gotten rid of the cell phone. I haven't maintained anything. Under your theory, I would be subject to a spoliation complaint.
No, Your Honor, I would not anticipate litigation based on that. I would anticipate a call from the police, and I'd anticipate a call from an insurance company. And in a way, it is a third-degree felony to leave the scene of an accident.
Is that the
you've
legal
witnessed.
standard,
No, I
though?
wasn't involved in the accident.
I know,
was just
but I actually have witnessed accidents and reported them and received calls from the police and received calls from the insurance company. Not for a second did I think I was going to get subject to a spoliation claim. That's my civic duty. But if I'm involved in an altercation
Well, but you know
in a
how I'm saying,
store-
in the car accident case, you know that there's been a problem. I mean, any reasonable person could conclude if there's been a car accident that there could be litigation, right?
Yes, and I am a potential witness
You know you're a
in
witness.
litigation.
And let's say you couldn't call, let's say you texted 911, but you didn't keep the text.
And your
And
question
then you get
is,
sued
why
for,
is it?
you get sued for spoliation because you didn't keep the text. Is that essentially where we're at? If
No,
we've-
Your Honor.
Okay.
We're not. And the court doesn't have to go that far.
I'm trying to figure out
because
how do you write this opinion? is what we're all
Exactly,
saying.
exactly. How far do we stretch that rubber band?
Well,
The
what-
reasonable
answer
anticipation
it
of
for us.
litigation.
How do we do it?
Exactly. And the answer to that is, when we have such a fact-intensive inquiry under that legal standard, the legal standard is indisputably reasonably anticipated litigation, not because I
you
think
think
so,
that's
because the
the-
courts say so. So it goes through jury determination when you have
The
a fact.
existing state of Florida law, or we would need to expand Florida law to get to the point where we say a third party has a duty to preserve evidence if they reasonably anticipate litigation.
You are not expanding Florida law, and we go through the whole litany of cases, starting with St. Mary's versus Brinson. We've got Palmacy Bamboo, where there was a flurry of litigation. In this case, we have a flurry of administrative litigation disputes. We've got the Hedinger, Hagopian.
Hedinger, though, later, the Fourth DCA in Royal Sunshine cites Hagopin and Brinson, which Hedinger relies on, and says that neither of those cases establishes a duty to preserve evidence when litigation is merely anticipated. So how is that the state of Florida law?
Your Honor, the problem with Royal and Sun Alliance is that outlier decision, because I cannot find, other than the Osmulski decision, which we disclosed under candor to the tribunal, but even in that case, they don't affirmatively state that a discovery request is required. Only Royal and Sun Alliance, and then you've got the Hedinger decision cited with approval in the Florida Supreme Court, recognizing reasonable anticipation of litigation, and then you have your own en banc decision.
In the context of a first party.
No, Your Honor.
Yes,
There
the
was-
legislature was a party to that action.
They
So
were,
they're saying
then
in the context of a
I
first.
apologize to the court. My reading of Detzner was there was no litigation yet, and I apologize to the court if that is what Detzner stands for, because Detzner, we cite Detzner and the cases that Detzner cites with approval for the rule in Florida that if litigation is reasonably anticipated, and those are the terms they use, anticipated, not ongoing, but anticipated, something in the future, if that's the standard.
Okay, well, how about this? They have the car accident. Judge Cohen stops briefly to see if he can help. He can't help anybody. While he's there, as he is texting 911, one person says to the other, "I'm going to sue you."
Going
Tomorrow.
to sue Judge Cohen.
No, he says it to the other driver. Judge Cohen just hears it. Well, now Judge Cohen has very much anticipates litigation. It's been expressly said. He's texted 911. 3 years later, he no longer has the text.
I don't think the text...
Spoliation claim?
No, Your Honor. I don't think the text is the same thing, but I think the question is, did
Why
Judge
isn't it the
Cohen
same
at the...
thing? I don't understand.
Because in the REMARK emails, these emails and documents are directly, even by her trial-level admissions, which I believe are at record site 397 through 404, she recognizes that she was, at that time, having extensive communications with third parties. This was way more involved than one text message. We're talking about deeply involved in communications
But that doesn't go to a duty. Does that go to, maybe that goes to one of the other elements, but how does that go to duty?
Because
The fact that there's 100 documents versus one document.
Because it goes to the anticipation of litigation.
No,
And it doesn't...
No. In my example, I said very clearly, the person said very clearly in front of Judge Cohen, "I'm filing a lawsuit tomorrow."
Right.
And so everyone clearly anticipated litigation at that point.
But, again, going back to what the court said in the Flagstar decision, what we're talking about are deeply factual inquiries. As a member of a jury evaluating that evidence, I would find it highly unlikely, highly improbable that anyone would anticipate the litigation with a text message, and ergo,
Okay,
no
well, let's
duty.
move on then.
So
The
to
emails,
answer-
I actually have a question about the emails.
Sure.
So you think you're missing emails? What else?
We believe that there were also documents associated with that hard drive, and that's the beauty about spoliation.
What evidence do you have that there were? You actually reference, in the record, at least, arguably some evidence that there were emails.
You're referring
at
to the
some
Third
point.
Amendment complaint, the attachments
Right,
to the Third
but
Amendment
what
complaint.
evidence was there that there were other documents, or is that speculation?
That, it's not speculation, it's an inference that the
From what?
court said in Hediger, Flagstar, can be made when there is spoliation. And we quote from the Goodman decision that says, you, the spoliator, and the lower court recognized this, how can you, the spoliator, and you read these in all these decisions, oh, I didn't know anything about computers, there was nothing relevant, I gave you everything relevant. In the Goodman decision, they gave everything relevant, they only deleted what was irrelevant. So in the beauty of the spoliation is when you have an effective spoliation, you get these kinds of questions.
Well, do you have to, she said there was nothing on it, so.
Of course she did.
But, well, hold on a minute. So does she have to, do we all have to maintain every computer we've ever owned? Because even though there's nothing that could be possibly on it?
If you
Let's say
reasonably
you have 4
anticipate
computers.
litigation.
Let's say you have 4 computers and only one of them you ever used for business. But you destroy this computer over here that was never used for business, and now we have somebody saying, well, there might have been stuff on that.
Well, that fact pattern doesn't apply here. She stated that she only used the dental office for sending her emails, and that she deleted all her emails, but the emails attached to the complaint show email chains. And remember, Sullivan, Shamrock tried...
On Sunday, right? Is that where you're going?
Well, not just on Sundays, but also business hours. She worked Mondays, 8 to 5, and Tuesdays through Thursdays, 7:30 to 4. So some of these emails are sent after 5 p.m.
Was the email,
So
was it a Yahoo account?
it's a Yahoo account.
Why didn't you go get the emails from Yahoo?
Well, the court can take judicial notice that Yahoo deletes emails within a year. And you can try to recoup them, but Yahoo may or may not comply with that subpoena. It's a good luck with that. But the emails we do have were public records requests sent to every state and local agency to try to get these communications. These emails are all that Patrick Sullivan, the Shamrock, could get.
Did you attempt to get the emails from Yahoo?
No, Your Honor, because by the time the spoliation had occurred, it was more that by the time they discovered, that is, the spoliation had occurred, it was more than a year.
You're well into your 5-minute rebuttal. Do you want to save the time or keep going?
I would like to fully answer Your Honor's question about the attempts to recreate the evidence. And it is manifestly unjust, and the courts have made a policy decision when it comes to spoliation. And to address the concerns about the rubber band, the reason the jury makes these determinations, including when it's a fact-intensive inquiry and it's disputed about duty, is because at some point we have to assess the credibility of the spoliator.
That doesn't help, because what you say with that is, well, you don't need to narrow the rule of law here because the jury will figure it out. But that results in a lot of people being sued who are third parties. Here you had a volunteer member of a planning board, who ends up getting sued, and that's a really wide net. So to say that the jury will figure it out, that's the test, doesn't help us in terms of crafting a rule of law.
And, Your Honor, what I would ask the court to do in crafting that rule of law would be to take the St. Mary's versus Brinson decision, to take Palmacy Bamboo, to take Miller, which admittedly did turn primarily on a promise, an agreement, but to take the decisions that we cite, Hediger, Hagopian, and Detzner, to take this court's own en banc Torres decision and to factor in Chief Judge Harris's thoughtful concurrence, because there is a policy decision being made here. We decide reasonable foreseeability as a basis for duty all the time. And it's manifestly unfair and unjust that the injured party who's suffering from the spoliation gets no recovery because the spoliator so effectively spoliated and thereafter, with self-interest, claims a right to not be sued because it was all irrelevant anyway, and I gotcha, you're never going to be able to find out.
Not saying
So-
that they can't be sued, they just can't be sued for spoliation.
I'll reserve my time for rebuttal. I respect the court's questions, and I hope I've answered them. I
Okay,
will
thank you.
reserve. Thank you.
Give her a little extra time.
Just a second, counsel. Okay, whenever you're ready.
Thank you, Your Honor. Good morning. May it please the court, Gary Glassman on behalf of the defendant appellee, TRACEY REMARK. I would like to go right to, I think, what is the heart, and the court has pointed out, is the heart of this case, this issue as to whether or not a non-party can be sued for a spoliation case when they have no idea about the underlying case whatsoever. This record...
That's a disputed, I don't think that they would agree that this individual had no idea about the underlying dispute. And so, you know, if we have a line from, I have no idea, to I was an eyewitness, I mean, at what point does a third party have some obligation?
I think that the only time that a third party would have an obligation when the evidence is very, very clear that they were put on notice prior to the lawsuit or immediately following the commencement. Let's take the Hagopian.
Is that notice some sort of legal, I mean, what does that notice look like?
I think if we look at it and take the example that you gave, Judge, you're a witness to this particular car accident, and you get out of your car, you take out your cell phone, as just about everybody does these days, and they take a picture. And they say, okay, you know, I got a picture, I give my name to somebody so they can contact me, and off I go. Now, the idea that at that point I would have a duty to preserve that is just too far reaching, because why am I, as some just non-party witness, now subject to this duty to preserve, which if I don't do, could land me in big financial trouble? But to answer your question, let's assume for the moment the attorney for the plaintiff sends me a written notice and says, I understand that you have a picture, and we would like you to keep that picture, and in fact, we'd like you to give us a copy, but until you give us a copy, please keep that picture because it could be very important for this particular case. At least there is some direct knowledge that the person receives, this non-party receives, and says, okay, I've got something here, and I better hold on to it.
Your rule of law would require some sort of notice from either a party or the lawyer for a party. Do you think that there are circumstances that wouldn't require a formal notice?
There would be some circumstances that would require a formal
Would not
notice?
require a formal
Judge,
notice.
I think if we get into that, we're going to go down this very slippery slope of, okay, how much is necessary for the notice, and, you know, was it given? I think we then get into that too far afield area.
What if the you know, the car accident and the vehicle's completely disabled, and so they call the tow truck to come get it, right? And as the tow truck is about to take the car away, the owner says, well, hey, don't destroy that car. You know, I'm going to file a lawsuit. Please take care of that vehicle. I'm going to come get it next week. And then next week rolls around and the car's nowhere to be found. That there's no letter there. You know, there's no subpoena there. Why isn't that enough?
I don't think it's enough, because I think just somebody saying it to them and saying, hey, look, there's a potential for litigation, just isn't enough, because again, you're
He told him, do not destroy that car. He keep that car. please, I'm going to file a lawsuit. I mean, how could it be more clear than that?
I understand. I just think, again, that when we get into this area, we're going to have, if we start stretching the rubber band of the rule as to this kind of preserving evidence and when you're on notice to do so, I think we've got to be very, very careful. And I think the situation that you're posing is just too speculative and now puts this burden on someone, this tow truck person, to say, well, I've got to hold on to this car. How long do I have to hold on to it? In what condition?
Well,
Why should I be burdened with doing that?
Well, maybe because the owner said, I'm going to file a lawsuit and I need that car, please don't destroy it or lose it.
Okay, I think, I want to answer the question directly. I think possibly in that scenario that you've given us, there might be a duty to preserve. And I think that we get into some of those cases, like the Hagopian case and the St. Mary's case, where we're not talking about a contractual or a discovery or a statutory duty. We're talking about someone being put on notice and being said, hey, you've got something that could be important to me.
They identified the thing that's important.
Yeah, you've got something that's important to me. I'm thinking about suing. More likely than not, I'm going to. So please hold on to that for me. That's different than the facts of this case. Now, I know Your Honor said that they would dispute the fact that Ms. REMARK had no knowledge of the underlying case, but the one thing I did want to say was that the record does not show any evidence whatsoever that Ms. REMARK had knowledge of the underlying case until she received that first notice of taking deposition.
And wasn't the computer destroyed after receiving the first notice?
I'm sorry.
And I understand it wasn't the Ducis Tecum.
Yes.
But wasn't the computer destroyed after the first notice was received?
The computer, what happened simply was there were first notice in May of 2011. There were at least 5 or 6 amended notices of taking deposition, not Ducis Tecum. During the course of the next 11 months, it was...
They were only seeking testimony at that point.
Exactly, and that's the point. That's why I don't think...
But it puts you on notice as to the litigation, and that was seeming to be, that sounded like the test that you were advocating, which is notice.
No, the notice must be something that tells you, I need something for this lawsuit, and you've got it, and I'm asking you to preserve it.
What's your best case for that legal principle?
The best cases are the cases that Judge Orfinger used. I don't think that there's a case that says just what I've said, but I think that Judge Orfinger relied upon the cases that said you've got to have either a contractual obligation, a statutory obligation, or a discovery obligation. And that case is the ones that we rely upon, and I think that Judge Orfinger was correct based upon the facts of
but
this
I thought you essentially conceded earlier that there could be a fourth scenario where, there is no statute or contract, but you're on notice of litigation and
I think there's enough...
the
again,
need to maintain something, right?
Yes, I think with the Hagopian, the St. Mary's, I would be hard-pressed to argue against those.
So there's 4 scenarios, and we're dealing with the 4th one here.
Right. And what I say here is that the facts of those cases are completely distinguishable from the facts of this case. First of all, those cases do deal with a party who is part of the action that's already taken place. I keep mentioning the Hagopian. I go into Publix, I buy a bottle of soda, it explodes, and I get injured. I take the remnants of the bottle of soda and I go over to the cashier and I say, hey, please hold on to these remnants of the bottle because I may sue Publix or the Coca-Cola company. And after a period of time, Publix gets rid of it. Okay, there you could find a possible spoliation by Publix, even though there's no lawsuit at the time. They were put on notice. They understood that there was going to be some litigation. In this case, we have nothing like that.
And, in that case, would it be fair to say that they knew that they'd even likely be a party? Or
Yes, yes. I think if they've got the bottle that breaks...
Unlike Judge Cohen observing the car accident where he knows he's not going to be a party, right?
Exactly. I think that that's the distinction that needs to be made, at least in this case, from all of those other cases, is that she had no knowledge of the underlying case. She was not served, as you pointed out, Judge, she was not served at any time with the complaint in the underlying case. Her first notice came when she was given this deposition notice, not ducis tecum. It took them almost a year before they decided that, gee, we may want to ask her for some documents as well. So let's do, on the sixth amended notice of deposition, they did a ducis tecum. Up to that point in time, the rule says when you're served with a notice of deposition, you're going to go in and give a deposition. If the deposing party wants to have documents, it's their obligation to tell you, bring us documents. Why should, when a person gets a notice of taking deposition, suddenly be required to think what it is that the deposing party wants? Why should they say, okay, I know I'm going to go in for a deposition, I'm going to answer questions, but am I supposed to bring documents? Am I supposed to save documents? That's not the deponent's problem. That should be the person.
Well, without the ducis tecum, they're not supposed to bring documents, right?
Exactly.
She wasn't, she had no reason to believe during those first, what was it, 6? 5 or 6? That she
was an original in 5.
That she was going to be asked to produce documents.
Exactly.
You say that she had no notice, but even before she became a member of the planning board, wasn't there a letter with significant number of attachments that addressed the issues that were?
Yes. And
Why isn't that knowledge?
Because again, it's no one is saying to her, you better hold on to these or keep a copy of these because we're going to end up in litigation. That's a big jump for someone who's sitting on a planning board, as you pointed out, a volunteer sitting on a planning board to make. In city government, local government, you get hundreds, if not thousands, of documents that cross you all the time, that cross your desk all the time, and we hold on to them because of the fact that we have, of course, the Public Records Act. But if there is a place that those documents go to, and in terms of the planning board, the person responsible for maintaining documents is the person who is the clerk of the board. So it's not that we're just throwing stuff away. Things are maintained. But to ask her to have to maintain everything without any idea that there's going to be litigation, I think, again, stretches that rubber band way too far.
Well, no. She knew there was litigation.
I'm sorry?
I mean, she knew there was litigation.
She didn't
before
know
she.
there was...
Am I misremembering the record? She knew there was litigation because she got served with a notice of deposition,
Yes,
right?
then that was the
so
first
she knew there was litigation.
That was the first time she knew in the underlying case that there was
Well, yeah,
litigation.
but you just said, hey, but without knowing that there's litigation, I'm just saying she knew there was litigation. She didn't know that they were going to seek documents from her, and she didn't know which documents they'd want, correct? But she knew there was litigation.
The underlying litigation, I believe, started in 2009. The first notice of taking deposition was not until May of 2011. So during those 2 years, there is nothing in the record that indicates that she had any knowledge of this underlying litigation. She was not a party. She wasn't. There's nothing in the testimony that says
When was the hard drive? I'm sorry, what was the date the hard drive was destroyed again?
That was destroyed in December of 2011.
So after she got the first notice of deposition?
Yes.
That's my only point. My only point is you said that she didn't know that there was litigation. I'm just saying she did know about the litigation.
If I made that mistake, I apologize,
Okay.
Judge. My only point is that she didn't know until she got the first notice of taking deposition. She didn't know anything about it before then.
So that's not good enough in terms of how you would structure the law in this area. You would have us write something that says you have to have specific notice as to the documents or items that are sought to be maintained.
Yes, Your Honor. I would, and I think the reason I'm saying that, not just because it benefits my client, but the reason I'm saying that is, what are we doing here? We're imposing a duty on someone who is not a party to litigation. We are potentially subjecting them to tremendous financial burden. If we are going to create a rule of law that is going to do that, I think we need to do it in a very strict manner, in a very conservative
Counsel,
way.
why wouldn't service of the complaint be enough? I mean, and I don't mean official service by the sheriff's deputy, right? But I mean, if they had sent her the complaint along with that first notice of deposition, right? She can see the issues. She can clearly see, I was involved. I remember this. I know what these issues are about. it doesn't seem like much of a logical jump at that point for her to know, okay, maybe I need to preserve some stuff.
Well, I can't really answer that one, Judge, because, well, I can, but I want to just point out first.
You said that she would have to know exactly what was going to be preserved. And I'm saying, I'm not, does it have to be that strict? I mean,
I think for a non-party witness, it should be, because again, we're going to be imposing a very severe, potentially very severe duty on this non-party witness. And if we're going to do that, I think the party that wants the documents should be very clear as to what it is that they want and what it is that they expect. And without that, I think we're being very unfair to non-party witnesses. It's just stretching the rule, and I can see the rule being stretched further and further till we get to
Counsel,
the
we're going to
point.
give both sides a couple extra minutes, so you don't feel rushed here, but talk about the difference between a first-party claim and a third-party claim in your mind. They seem like there's some substantial differences to me, but...
Yes, Your Honor, and there are substantial differences, and in the first-party claim, you're dealing with somebody who, more likely than not, because they are a party to it, they understood that there were documents or evidence. I keep saying documents, I want to keep it broad, that there should be evidence that should have been preserved. I am Publix in the Hagopian case. I get sued that way. I should know that I should have kept that bottle. In a third-party situation like we have here, you have to examine what it is that the person knew and when they knew it, and what was being requested of them. And in our third-party case like this one, where she was not a party to the underlying case, the evidence is simply that she had no knowledge of this case until that first notice of taking deposition, and until she received the...
She had no notice of the litigation.
Yes, I'm sorry. If I misspoke, I apologize. She had no notice of the underlying litigation until that time, and she had no knowledge of any desire for documents until 4 months after she had disposed of this 1998 malfunctioning Dell computer. They had a year. If they wanted, from a practical standpoint, they had a year. If they wanted documents from her, they had 6 other opportunities to ask her and didn't do so. And, I know we're going a little bit far afield here, but there was some question about the integrity of Ms. REMARK and her wanting to, get rid of documents so that she could preserve herself and take care of herself in this case. I would just point out that she got that first notice in May of 2011, and the computer itself wasn't disposed of until December. If somebody really wanted to hide documents, they would have gotten rid of that computer much, much sooner. So there was some question about her integrity in this, and I do want to point that out. I don't think she in any way was trying to hide anything on that computer. There was some question I know the court asked about emails. In the underlying case, they could have gotten those emails from Yahoo. They could have put another computer right in front of Ms. REMARK at the deposition in the underlying case and said, pull up the account and show us your emails. It didn't have to come from that computer, her Dell computer that was disposed of. There were other ways to get this.
With a Yahoo account, I mean, I assume you can access that, as you just said, from any computer. Was there any evidence below that she was accessing that account, other than speculation, that she was accessing that account? Well, let's see. I'm sorry, let me rephrase it. If she was accessing that account from the computer that was destroyed, is there any evidence that the emails would have still been on that hard drive as opposed to in the cloud somewhere?
Yeah, no. She testified, and there was nothing to dispute this. She testified that she never used the Dell computer.
No. Let's assume for a minute she did use it.
Oh, okay, I'm sorry.
Okay? She did use it. She signed on to Yahoo and sent, official emails from that computer using the Yahoo account. And I just wanted to know, is there anything in the record to establish, one way or the other, whether or not when you do that, and I don't know what the technology is, but when you do that, are those emails stored on the hard drive, or are they stored only in the cloud with Yahoo? Or is there just nothing in the record?
You're talking to a person who has limited knowledge and ability.
I'm not asking for your knowledge, I'm asking
Okay.
for the record knowledge.
Okay.
Is there anything in the record?
No, not
Okay.
I've read this record a couple of times, and I don't know of anything that's, to directly answer your question.
That was my,
I don't know
and we'll
anything
give you a
that's-
couple extra minutes there too, but, so you have about 3 minutes, let's say.
All right, thank you. I appreciate that, Judge. Going forward from this issue of the duty, I understand that if this court reverses and finds that there was a duty, I do want to make it clear that I do not believe that the record shows that the plaintiff has in any way satisfied the other elements of a spoliation claim, and therefore I'm concerned that if they do reverse, that they not be granted summary judgment on their motion, because they did have a competing motion for summary judgment. Many, many years ago, I had a case, Orange County. The court granted summary judgment. We went up to the 11th Circuit. They not only reversed, but they granted summary judgment for the plaintiff, who hadn't even asked for summary judgment. So it was not my best day as a lawyer, and I just always try to be careful that if there's two competing motions, that their motion not be granted by this court, because I don't think that they've shown in the record that they can meet all the other elements of the complaint for spoliation. I think just quickly, the other issue I would just like to touch upon is the motion for rehearing. In this particular case, there was the issue of outstanding. There were 10 depositions that were outstanding. They filed a rehearing motion saying that, well, the court shouldn't have granted summary judgment because we have 10 outstanding depositions. Well, they never told the court that. They never advised the court that there's these outstanding depositions. We went forward with the 2 hearings. They got an adverse ruling, and then we get the hearing, the motion for rehearing saying, oh, by the way, there's these 10 other depositions. I don't think that's the way it's supposed to go. Moreover, in the motion itself, they only said, this is what we expect these deponents will say. That's not good summary judgment evidence. You've got to have an affidavit. You've got to have some sworn testimony. So I think Judge Orfinger correctly decided the motion for rehearing, denied the motion for rehearing. And if there are no other questions, then I will retreat and simply ask that the court affirm the judgment of the trial court granting summary judgment.
Thank you, counsel. And we will give the appellant 2 extra minutes as well. So you have 41 seconds left of your original argument plus 2 minutes. 2 minutes,
Thank you,
41
Your Honor.
seconds.
What I'd like to do is address the court's questions in reverse order, because those are the freshest in my mind. Record site 87, it was raised before the court at the summary judgment hearing that there were outstanding depositions. True, there was no request for continuance at that hearing, and because Shamrock never anticipated that the summary judgment would be granted, but they did raise it on record site 87. In addition, the cases are legion, and this court knows that you can raise these issues for the first time in a motion for rehearing, and because they were witnesses to be deposed, these witnesses, we can only proffer what their testimony likely would have shown and what their testimony would have revealed. And let me give the court record sites 1041-43. The witnesses were Paul McKittrick, Bill Redman, Todd Moynihan, Joseph Hopkins, Peter Zahn, and Richard Zahn. Those are among the deponents. The Dell's computer, counsel admitted at the hearing, record site 24, there is a significant, quote, significant factual dispute, close quote, over whether she ever used that computer through which she drilled her hard drive. I'm quoting the significant
And
factual
so answer my
dispute
question that I asked
language.
counsel before. Was there anything in the record? And that's the key part of my question.
Sure.
Is there anything in the record to demonstrate that when she sat down at that 1998 computer, logged on to Yahoo Mail and sent emails from that, is there anything in the record to indicate that those emails would reside on that destroyed hard drive as opposed to Yahoo's cloud or, whatever we call it?
No, Your Honor, and to aid the
But
court's
without
review,
that, how do you get there?
because we rely on the adverse inference. We rely on the inference that the hard drive was destroyed, and the lower court said, I've owned a lot of computers, I've never drilled one. The emails were destroyed because a jury can reasonably infer they were destroyed
No,
because
but
they
that's
would
the
have been
question. Were the
harmful.
emails destroyed, right? I said, if they weren't residing on that hard drive, then they weren't destroyed. And
So
so,
the emails, I think I know what Your Honor's asking. The emails would either be kept in the cloud or also saved on the hard drive. And as to that evidence, we don't have that because she says she deleted all her emails, yet we found these email strings from emails that she sent, emails she received, the ones that are attached to the complaint.
There's a lot that can be recovered off of a hard drive, even though you think you've deleted it.
If you have not drilled through it, because the drilling leaves these metallic
I
particles.
guess I haven't gotten to answer my question.
I apologize, I'm
No,
trying to.
it's a different, I think we're just missing each other. But the question is, did you offer any evidence that the emails that were going through Yahoo, let's assume for a minute that everything you said is correct. She was sending emails from that 1998 computer related to official business through Yahoo. Let's assume all that's correct. Did you offer any evidence that those emails would reside or potentially could reside on the hard drive as opposed to in the Yahoo cloud?
Only as a summary judgment non-movement, the jury can infer that the emails were saved because we have the email chain showing prior emails. In other words, she testified she deleted them all, yet here we are with emails attached to the third amended complaint showing these email chains. And at that time, had the hard drive not been destroyed, they could have been recovered in addition to the Yahoo. And just in closing.
Counsel, we'll give you another 10 seconds. You've gone 3 extra minutes.
Thank you. In closing, I'd like to read from this court's en banc Taurus decision. If one knows that he or she is about to become involved in a civil action, not sued, involved, this alone should be sufficient special circumstances to impose a duty of care to preserve such evidence in such potential party's possession that a reasonable person would foresee it material to that action. We ask that the court reverse summary judgment. There are multiple disputed issues of fact.
Thank you, counsel.
Thank you for your time.
Thank you. Have a safe trip home.
Thank you.